Hey, good morning. I'm just responding via video to an email I received. Someone who was confused as to how she could have been denied on initial. So there's still plenty of time and space to change that. But this is a person who is over 50, under 55. And it looks like when she reads the denial letter, to her, it doesn't make much sense because it says, something, it sounds like to the effect that we realize you can't do your prior work. Remember, that would be that past relevant work of the past 15 years as of now. That's the time frame they look at. But that she could do other less arduous work, whether it's less arduous mentally or physically, I don't know. And she's looking at it from a perspective, I think, where she's thinking, I have no other skills except the job I did. Therefore, I can't do anything else. That is not really accurate. Okay. That's not to say I don't think she would be disabled under the law, depending on how it was worked up necessarily. But the concept of I don't know anything else because I've only done this kind of job. And perhaps it's an unskilled job. We just learn a few tasks on that job, but it's not considered a skilled job. If you can do other work that is also unskilled, because remember, if it's unskilled, it means you don't have to come to the table with previously learned skills from other jobs. So it can involve, a job different than what you did, as long as the RFC, residual functional capacity, that has been assigned to you by the SSA, rightly or wrongly. And we usually have to argue that it's inaccurate and try to get that, evaluation conclusion changed. It could be that, you could do any other unskilled job, assuming that it fits within your RFC and there's no special rules such as the grid that would knock you out of it. Okay, so like if you're 53 and you have no transferable skills because your prior job was unskilled, and you can do light work, you're not able to do medium or heavy work, but you could do light work, it's very probable that you would be found not disabled because you wouldn't be doing your prior job, which might have been a little heftier than light. But if you can, you're reduced, but you could still do light work, they're generally going to find that you are not disabled. So your job is to show that you actually couldn't do that light work. Maybe you can't be on your feet 6 out of 8 hours. Maybe you cannot lift up to 20 pounds occasionally. So, when you go through the denial, they give you that little blanket thing. And if you look at our playlist, I'll put it at the end if they'll let me connect it. Other that, or I'll put it down in the comments about the denial number 1, 2, 3, 4, 5. 4 and 5, I think, would touch on this particular kind of denial and the language she's seeing. So denial number 4, denial number 5, I think. And it'll help explain that even if you have no skills, that's fine. There are unskilled jobs out there that don't require that you have skills. I feel like I want to say Walmart greeter, or something like that. But there's a lot of unskilled jobs, very important jobs. Some of them pay pretty well too, but they're out there. So you have to look at all the vocational factors of that job and then point out where your impairments, as per your medical records, would prevent you from doing that particular task required by that particular occupation, in the duration or frequency or speed in which it must be done for that job. And then you can get rid of that job by showing that you can't do it. But you have to show it through the medical records, not just saying what you feel and how you feel you can't do it. You need to point out specifics. Okay. All right. I hope that helps. But you have, I think this person has a lawyer, and this is obviously just general information, but hopefully the lawyer will explain it to you better, with your specifics. And I'm sure the lawyer is doing what he or she can to guide you in terms of the medical evidence that will be needed. Don't take it to heart if you're denied on initial. As those denial reasons say, there's very, very few times would I recommend someone not even bother appealing. it's more on the rare side. And usually that would be if you have zero evidence because you haven't even started treating yet. You filed because you probably can't go back to work, but you haven't gone to the doctors yet. And you have no evidence. So you just wasted half of the evaluation process where you could have won because you filed perhaps a little prematurely because you didn't have any of the goods. So there are those exceptions to how I think most people should appeal. There are times when I don't. Sometimes it's better to just start anew. Anyway, but there are also limits. So you have to make sure all your dates line up, before you make that decision, because you don't want to kill your case either. So that'll depend on some technical factors that need to be analyzed. Okay. Hope that helps. Bye.